The Supreme Court decision in the case of People of the Philippines versus Antonio M. TALAUE. While proof beyond reasonable doubt is meant to be that, all things given, the mind of the judge can rest at ease concerning its verdict. Reasonable doubt is defined as that doubt engendered by an investigation of the whole proof and an inability, after such investigation, to let the mind rest easy upon the certainty of guilt. Reasonable doubt refers to the possibility of innocence based on reason and common sense, arising from the evidence or lack of evidence, as the case may be. It is a term often used, probably pretty well understood, but not easily defined. It is not mere possible doubt, because everything relating to human affairs, and depending on moral evidence, is open to some possible or imaginary doubt. It is that state of the case, which, after the entire comparison and consideration of all the evidence, leaves the minds of jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charge. The burden of proof is upon the prosecutor. All the presumptions of law independent of evidence are in favor of innocence, and every person is presumed to be innocent until he is proved guilty. If upon such proof there is reasonable doubt remaining, the accused is entitled to the benefit of it by an acquittal. For it is not sufficient to establish a probability, though a strong one arising from the doctrine of chances, that the fact charged is more likely to be true than the contrary, but the evidence must establish the truth of the fact to a reasonable and moral certainty, a certainty that convinces and directs the understanding and satisfies the reason and judgment of those who are bound to act conscientiously upon it. This we take to be proof beyond reasonable doubt, because if the law, which mostly depends upon considerations of a moral nature, should go further than this and require absolute certainty, it would exclude circumstantial evidence altogether. Here, there is reasonable doubt when the prosecution failed to prove, 1. that TALAUE had the duty to remit GSIS premium contributions, and 2. that he intended to commit or perpetrate the act prescribed by Republic Act No. 8291. At the outset, there is no showing that TALAUE, as municipal mayor of Santo Tomas, Isabela, had the positive duty to remit the GSIS premium contributions of all employees within his political subdivision. The Local Government Code of 1991 refers to municipal mayors as chief executives and not heads of offices as contemplated under Section 52 paragraph G of Republic Act No. 8291. More importantly, nowhere in the Local Government Code of 1991 does it include the remittance of GSIS premiums as part of the duties of a mayor. In addition, no reference was made to any internal memorandum or practice within the municipality of Santo Tomas, Isabela, regarding the mayor's participation when it comes to remitting GSIS premium contributions. On another score, the court finds as misguided the assertion that TALAUE must be convicted on the mere characterization of the crime involved as malum prohibitum. In the recent case of Valenzuela versus People, the court made a distinction between intent to commit the crime and intent to perpetrate the act, such that in crimes classified as mala prohibita, the prosecution must still discharge the burden of proving that the prohibited act was intentionally done by the accused. Thus, dispensing with proof of criminal intent for crimes mala prohibita does not, in any way, discharge the prosecution of its burden to show that the prohibited act was done intentionally by the accused. On this note, it is important to distinguish between intent to commit the crime and intent to perpetrate the act. While a person may not have consciously intended to commit a crime regarded as malum prohibitum. He or she may still be held liable if he or she did intend to commit an act that is, by the very nature of things, the crime itself. Thus, for acts that are mala prohibita, the intent to perpetrate the prohibited act under the special law must nevertheless be shown. In contrast to crimes mala in SC, which presuppose that the person who did the felonious act had criminal intent in doing so, crimes mala prohibita do not require such knowledge or criminal intent. Rather, what is crucial is volition or the intent to commit the act. While volition or voluntariness refers to knowledge of the act being done, as opposed to knowledge of the nature of the act, criminal intent is the state of mind that goes beyond voluntariness, and it is this intent which is punished by crimes mala and SC. To hold an offender liable for an offense that is malum prohibitum, it is sufficient that there is a conscious intent to perpetrate the act prohibited by the special law, for the essence of mala prohibita is voluntariness in the commission of the act constitutive of the crime. Succinctly put, for crimes mala and SC, there must be proof of criminal intent, while for crimes mala prohibita, it is sufficient that the prohibited act is done freely and consciously. As applied here, even if a violation of Presidential Decree 957 is malum prohibitum, it must still be established that the accused had the volition or intent to commit the prohibited act, which is the non-registration of the subject contracts. Notably, and as pointed out by Valenzuela, even the information filed against him charges him for willfully, unlawfully, and feloniously failing to register the subject contracts. In this regard, and consistent with the preceding discussions, there must at least be a showing of his volition or intent to not register or cause the non-registration of the subject contracts through his active participation or by conspiring with others to commit the crime. Absent a showing of such participation done willfully, unlawfully, and feloniously, the prosecution failed to discharge its burden of proving Valenzuela's guilt. As applied to the instant case, the court finds that the prosecution miserably failed to demonstrate that TALAUE had the volition or conscious intent not to remit or cause the non-remittance of the GSIS premium contributions of the employees of the municipality of Santo Tomas. He was led to believe that the GSIS premiums for the year 1997 had already been remitted because the DBM had already withheld 5 million pesos from the municipality's budget. This mistaken belief negates any showing that he intentionally caused the non-remittance of GSIS premium contributions.